Thank you, Your Honour.
Yes, thank you, Ms. Cowan. Thank you again.
Services next.
Thank you.
Thank you. Ms Stubbs, you're the Chief Executive Officer of Northcott Disability Services.
I am.
And Ms. I beg your pardon?
I am.
And Ms Smith, you're the Business Development and Partnerships Coordinator of
Yes,
the
I am.
service. Thank you. I invite you to speak to your submission.
I'd like to start by thanking the Commission for the opportunity to speak. We're speaking on behalf of Northcott, not on behalf of people with disability and on behalf of all disability service providers. However, we think that our experience over 85 years of providing disability services across New South Wales, first with Crippled Children's Society, gives us some level of insight into the sorts of issues for people with disabilities who experience child sexual abuse, and which we don't believe have been adequately addressed in the Commission's paper on reparation and redress. Northcott itself used to provide schools, orthopaedic hospitals, used to provide residential homes. We no longer do any of those things for children, but we certainly did that for a large part of our history. We don't, at this stage, have any allegations of child sexual abuse against Northcott, which is not to say we don't believe it never happened in any of those institutions, but we have no particular instances. We have in place in our current organisation, which is much more community-based, but still provides services to some 13,000 children and families and people with disabilities across New South Wales and the ACT, and largely provides services to young people under the age of 25. So we still have a lot of experience with providing services to young people. We have very strong and coherent policies and programs in place to deal with reports of sexual abuse, protection of children. We've worked very closely with the Ombudsman in New South Wales and are very happy with the reporting of sexual abuse processes that we work with the Ombudsman. However, we think there are some major issues in terms of reparation and redress that aren't addressed by the Commission's paper, because particularly of the needs of people with disabilities. And Hilary prepared the paper, so I'm going to let her talk about them.
Thank you, Kerry, and thank you, Commissioners, for hearing us today. When we read the consultation paper, what we were most struck by was the fact that there was a very strong focus on the fact that a redress scheme by design needed to be a scheme that plugged existing gaps. So rather than create a whole new parallel scheme to existing support such as Medicare, for example, a redress scheme would work with what we already have and then augment that to the extent that was needed. That's the right approach, I think, and that's our organisation's position. But what was missing was any recognition of the fact that those gaps can be a gulf for a person with disability compared to a person who doesn't have the same particular physical requirements, communication requirements and other additional support needs that a person with disability may have. We know that people with disability are highly more vulnerable to all forms of abuse as children and as adults than as people without disability. And we've given a number of references to that fact in our submission. Factors such as communication can play a part where a person may never have been able to tell a perpetrator, I don't want you to do that to me, or may never have been able to tell a protective adult ally, this happened to me and it was wrong, or may still not be able to say, something happened to me years ago and I want to be able to seek redress. There are physical complications for some people with disability who may have been vulnerable to abuse because they simply could not flee a perpetrator, or who may have been more vulnerable to abuse because they have specific needs with regards to intimate personal care, which another person doesn't have, regarding assistance with toileting, showering, and physical contact by another person with intimate parts of their body. What we felt was that there needed to be greater recognition within any redress scheme design and in any consideration of the existing parameters around civil litigation and what changes may need to be made there. There needed to be much greater consideration of access issues for people with disability, all forms of disability, I suppose, too. So I've spoken about communication barriers, I've spoken about physical disability, but there are many other experiences that people with a whole range of disabilities have which may make the existing scheme difficult to access. I think the other point that I would make is that the existing Medicare framework, for example, is already provides a range of services to all Australians, which is great, it should. But for a person with disability, it may already be inadequate. And I think there's a risk in suggesting that the redress scheme could piggyback on, for example, the better access to mental health care or the chronic disease management plans that exist currently. They may already be inadequate for a number of the people we support. I know lots of families that I've worked with in my 5 years at Northcott have exhausted those resources annually really quickly because there are so many other things that they need to procure, I suppose, in order to achieve a good life. And that can be things like a behaviour support plan, it can be things like mental health care, it can be things like prescription of a wheelchair, mealtime swallowing assessments, a whole range of things that keep a person physically safe and well to a certain degree. But if you've already absorbed your 12 or your 15 sessions that you're eligible for in a year, that means that you may not have the opportunity to touch on any of your psychological care needs that may arise from a past experience of trauma. The other point that I would make on that is that many people with disability need longer to have a meaningful conversation with somebody. So if an example were that someone was to seek 6 sessions of counselling, I may be able to get 6 one-hour sessions of counselling and have a certain amount of conversation in that time. Some of the people that we support are non-verbal and need a lot of time to be able to use alternative means of communication to get that same amount of content out. It wouldn't be fair to say, okay, well, everyone gets 6 hours on that basis, because, some people who we support, for example, need to type their messages into a device such as an iPad. But if you have, in addition to being non-verbal, a range of physical mobility challenges, shall we say, it might take you quite some time to even type that message out, then have it read by the person who you're communicating with, then interpret their response to what you've said, and then turn around and start typing your next sentence. It's a real process, and it requires quite a lot of skill on the part of a communication partner to be able to engage in a really meaningful conversation with the person who they're talking to. Within our organisation, many people are really skilled in having those day-to-day conversations with a person with disability, because it's part of what we're used to doing. We support really diverse range of people, and some of those people use really diverse ranges of communication. It's not our job on a day-to-day basis, though, to have therapeutic conversations with regards to previous child sexual abuse as an organisation, and many of our staff would not be skilled to do that. So what a redress scheme needs to be able to provide is people who can bring that therapeutic clinical expertise to that particular area and combine it with an ability to communicate with people in a whole range of different manners. I think there is one other point that I would like to make on that front. Northcott has invested in a number of the people who we support in creating what we call a Champions program. So these are people with disability, with a whole range of disabilities and from a range of backgrounds and a range of ages and cultural backgrounds as well, and different parts of New South Wales. We've got regional, metro, who have all been through quite a detailed development program in terms of their presentation skills, public speaking skills, facilitation skills, mentoring skills, and one of their roles is to work with service providers, with other people with disability, with other members of the community to discuss issues like how you implement the human rights of a person with disability, how you communicate with a person with disability, how you set a plan with a person with disability to help them achieve a good life and identify what a good life looks like for them. We would recommend respectfully that the Commission took some time to meet with our champions or with champions from another similar program to learn about access from the perspective of a person with lived experience of disability. It's not something that Kerry or I are qualified to talk to today. Certainly we can express our experience as a provider, but a person with disability, whether or not they're a survivor, could provide particularly useful evidence to the Commission regarding what else ought to be considered in designing a redress scheme so that it was able to meet the needs of all survivors when we recognise that people with disability are likely to be a large cohort within the broader group of survivors.
Thank you, Ms Smith.
Thank you.
Can I just raise a couple of issues? And thank you for your perspective, which is a little different to any of those that we've heard from. I'm not sure I really understand what the consequences are. Am I right in thinking that you're identifying that we may not have written enough about the way in which a disabled person might engage with a redress scheme? Is that...
Certainly. In our submission, we mentioned a number of concerns, and one is really that we couldn't really see people with disability in the consultation paper. The reason we believe that people with disability need to have their specific needs addressed in this paper, or at least in the scheme design, is there are a number of factors. One is that the existing system we don't think will do enough to support a person who needs longer or who needs different support in order to be able to access the scheme and get full use of the scheme. Another, though, is the fact, and we mentioned in the paper, I haven't spoken to it yet this afternoon, the fact that many survivors with disability may not identify as such, and there needs to be work done around helping those people to identify and then make an informed choice about whether or not they want to seek redress. I don't think it's appropriate that we just assume that only those people who know that something applies to them pursue it.
Well, I infer from what you've just said that you do understand that there's a difference between a discussion paper looking at the concept and then the ultimate design.
Yes, absolutely.
Which is why we're making a suggestion.
Do I understand you to accept that bringing these matters to our attention is important, but you also accept that they are details that would have to be worked out in the detailed design of any scheme that might be adopted?
Yes, certainly. Certainly, right? Yes. And we did mention in our paper as well that we would hope to see that there was peak representation involved in the scheme design, right, specifically so that there's expert subject matter knowledge, I suppose, who are able to inform that design process.
Speaking for the Commissioners, we wouldn't have any doubt between us that that's right.
Sure.
Secondly, you speak of the monetary payment and the institutional factor. Can I say that was deliberately drafted to be vague so that we could hear from people like yourselves about what particular factors there might be that relate to the particular institution? And do I understand correctly what you're saying is that space needs to be filled for disabled people perhaps by the fact that they were particularly trusting in an institution that provided for them with their disability? Is that
not necessarily particularly trusting, it's just that there may be, in terms of the monetary space, people with disability are almost always, if they've been in an institution, below the poverty line already. So some of the complications of working out what the monetary factor might be in redress for people with disability may even be more difficult, particularly if they're not aware that they have been abused or you haven't been able to establish abuse. What we're suggesting is that doesn't seem to have appeared in the principles of the paper, and we understand that the design of the scheme would look at that. We're asking for more involvement of appropriate people in the design of the scheme.
I'm not sure. You said I understand what you're saying. Okay. When I look at your written document, what you've focused on is what we call institutional factor, which is a component, I think it's 20% of the, possibly, of a suggested grid. But the numbers could vary, but that's the component that I thought you were focusing on.
That's true. We did make comment in the submission where we said we just thought it wasn't clear how that would apply to a person with disability. The consultation paper to us suggested that the thinking around institutional factor was some institutions existed to remove children from prior harm. So, a foster care group home may be an example where a child had been removed from their parents due to a perception or reality of existing harm within the family environment, and that prior abuse had made the child more vulnerable to further abuse once they entered the institution. Children with disability are a different cohort in the sense that they were more vulnerable to abuse by dint of their disability rather than by dint of any prior experience of abuse. I suppose that's the point that more that we were trying to make. So it may not be that a child with disability had been previously abused before entering an institution. It was really just the norm of the day that kids went and stayed in hospital schools, for example. With that in mind, I think it's on the one hand important not to characterise those children as survivors and their parents as having been all part of the context that preceded their entry to an institution. And equally, I think the point that we made in the consultation paper was that there needs to be some more holistic or more sophisticated assessment, I suppose, than just saying, okay, you were in this type of institution, therefore you get 15 out of 20, or you were in this type, so you don't get an institutional factor score.
And then they still beat an institution.
Are we talking about the institutional factor component?
Yes.
Yes.
Otherwise, you're accepting the other elements that have been suggested as fulfilling the obligations of the matrix.
So the other factors were the severity and the I can't remember the terminology that was used for the other component. I think broadly, yes, we were accepting of the concept, but the point that we made again was that quite sophisticated assessment needs to be brought in the case of people with disability, particularly because we know there's a high risk of misassessing and quite often underestimating the impact that something can have on a person if they're not able to articulate.
So I'm trying to work out, are you saying that, again, care needs to be taken with the assessment process? So when you design your scheme, the assessment process needs to be mindful of the particular circumstances of disabled people? Or are you saying that any matrix that you design should be different for disabled people? Do you understand?
No, we're not trying to propose a different matrix for people with disability. I think what we're trying to propose is a matrix that captures the experience of all survivors, but that is sufficiently sensitive to the different experiences of different survivors, of which people with disability are a large cohort.
So again, we're back at scheme design elements. Is that where we are?
Yes.
Yeah.
But what you have raised is a fundamental difference between the general out-of-home care population group and those children with disabilities that were taken into residential care within the disability sector. And am I right that you're saying to us we need to be particularly attentive, that there is in fact a very different philosophical understanding of that care from the general foster care population?
Yes, I think that's true as well.
And that would have been identified by, as you've indicated, by many parents who voluntarily place their children into disability care in the expectation that that would provide a safer and better environment for their children in that care placement.
Yes, and they were encouraged to do so by both the medical profession and the state, and believe they were doing the right thing for their children.
So therefore, in the design and the way in which the scheme is implemented, those that are implementing need to be attentive to those differences.
Yes.
And I think that that's a point that you've raised. Can I raise a second point, and you're the only group that has done so, is the National Disability Insurance Scheme. You have a paragraph in the document about that. Can I just understand this? You're cautioning against the view that the NDIS will in fact resolve some of these issues in terms of better service delivery. Is that correct?
So, yeah, absolutely, because the National Disability Insurance Scheme is designed to give people with disability, to take them to what they need to live a reasonable adjustment to live a normal life. That should not mean that they are denied access to the other mainstream services in the same way as anyone else. So it is not a compensation for not being able to access the mainstream services to get them to the stage that they can. Those mainstream services need to be accessible to people with a disability in exactly the same way, with the extra help that they need, as they are accessible to everyone else. So, for example, mental health services need to be able to deal with someone with a disability as they need to able to deal with someone without a disability. Similarly for Medicare, similarly for the other services.
That's a central tenet of the National Disability Agreement and the UN Convention on the Rights of Persons with Disability, that it's not the responsibility of the specialist disability system to look after people with disability in a bubble over here. It's the responsibility of the specialist system to get those people to a point where the rest of society then accepts them and has all of the structures in place to be able to do that fully.
So a practical illustration of that, assuming a person has been sexually abused whilst in care and required particular trauma-informed care or particular therapeutic services, Is it your view that that is likely to be provided under the NDIS, or would one look to the mainstream services for that sort of service?
Mainstream should be provided by, and it won't be provided by NDIS. They are not in the business of providing those sort of services.
Thank you.
Can I take you to a different issue? It's the last page of your submission when you talk about vicarious liability. And you say institutions should not be held vicariously liable. But what's your view about reversing the onus of proof so that an institution would have to satisfy the court that it had done all that it could reasonably do?
This submission was developed with our board's involvement in it as well. I think, in general, I don't think we have a position prospectively about vicarious liability. I'm probably taking a personal view. I'm quite happy with vicarious liability prospectively. Retrospectively, maybe a different issue. Yeah.
Yes, all right. Thank you.
Thank you, Your Honour. That completes today's evidence.
Well, thank you both for your help. You raised for us a very important issue, but one which few others have raised. So thank you.
That's what we noted.
Thank you.
And then it's 10 o'clock in the morning, isn't it?
It is, Your Honour.
Very well. We'll adjourn until 10.
A person-centred client.